Good afternoon, folks. I've got discussion B for you. We're discussing, should you remove a spouse that has dementia from the deed? Okay, so that is today's discussion B for you. Let me get set up for the show and then we'll get going, okay? Thanks. Okay, let me grab my notes and I'll be right with you. Okay. Should you remove a spouse with dementia from the deed? On your open page is introducing an elder law attorney's explanation of a very specific, very sensitive issue. How homeownership should be handled when one spouse has dementia, especially in relation to Medicaid rules, asset protection, and timing. Below is a clear, structured explanation based primarily on the surrounding page content. Core idea of the video / page. The page frames the question as a real-world dilemma families face when dementia progresses. It doesn't even make sense to remove a spouse with dementia from the home deed. The elder law attorney in the video emphasizes that home ownership decisions matter and that timing is critical because of Medicaid's rules around asset transfers. Why this question comes up. Families often consider removing the spouse with dementia from the deed because they worry about protecting the home if the spouse eventually needs Medicaid to pay for long-term care, avoiding the home being counted as an asset, simplifying inheritance, or preventing future disputes. Ensuring the healthy spouse can stay in the home without complications. The video acknowledges these concerns and explains that the legal consequences can be significant. What the elder law attorney highlights. Based on the page content, the attorney stresses 3 major points. 1. Deed changes are not simple. Removing a spouse from a deed is a legal transfer of property. When dementia is involved, capacity becomes a central issue. 2. Medicaid has strict look back rules. Medicaid reviews financial transactions, especially transfers of property up to 5 years. A deed change may a deed change made at the wrong time can trigger penalties or delays in eligibility. Timing is everything. The attorney underscores the earlier families seek guidance, the more options they have. Once dementia has progressed to the point of incapacity, the spouse may no longer be able to legally sign a deed, and guardianship may be required. Capacity matters. If the spouse with dementia cannot understand the transaction, they cannot legally sign a deed. This means a deed change may be impossible without court involvement. Attempting to do it anyway could be invalid or even considered exploitation. Families must be extremely cautious and seek legal advice early. Understand the underlying message. The page's takeaway is not yes or no. It's don't make this decision without an elder law attorney, and don't wait. The attorney is essentially saying the home is a major asset. Medicaid rules are complex. Capacity issues limit your options. Proper planning protects both spouses. The single most important takeaway in removing a spouse with dementia from a deed is legally possible in some situations, but it is highly regulated, time sensitive, and must be guided by an elder law attorney because of Medicaid's look back rules and the spouse's capacity. Okay, just like I said before, shows today will be 3 parts. So here we go with part 2, second half of B for you. Okay, the title is On the Deed: Mental Wellness and Capacity to transfer real estate. Based primarily on the surrounding page content from your open tab. The core idea of the page. The article explains how mental wellness, cognitive decline, and legal capacity affects a person's ability to transfer real estate. It walks through common family scenarios. Okay, especially dementia, and clarifies who can legally sign a deed when a transfer is valid, and what happens when someone can no longer understand the transaction. The page is not giving legal advice, it's giving a framework for spotting issues and knowing when to involve an attorney. Why mental capacity matters for deeds. A deed transfer is a contractual act. The page emphasizes that a person must understand what they're signing, the property's value, the consequences of transferring it, and who will receive it. So even someone diagnosed with dementia may still be legally competent if they can understand the property's value, recognize close relationships, express consistent wishes, grasp the consequences of signing. If they cannot, then they cannot legally sign a deed, and any transfer could be challenged later. Okay, guys, now here's a couple scenarios for you to get the grasp of what's going on with today's show. So, scenario 1, my parent has dementia. Can I transfer the deed to myself? The article explains you cannot simply transfer the deed for them. A professional capacity evaluation is often needed. If they still understand the transaction, they can sign their own deed. If they cannot, if they do not understand, then an authorized representative must sign. Someone with a durable power of attorney or a court-appointed guardian or conservator. Without one of these, no one is legally allowed to sign. Scenario 2, planning ahead with power of attorney, POA. The article stresses that POA must be created before capacity is lost. Key considerations: non-durable POA works only while the person still has capacity. Durable power of attorney continues even after incapacity. Springing POA activates only when incapacity is formally determined. A POA can be limited to real estate tasks, such as signing a deed. Scenario 3. When a deed transfer can be challenged. The page notes that although recorded deeds are presumed valid, they can be challenged if the signer lacked capacity, there was undue influence, a representative acted outside the person's best interests. In extreme cases, courts can void the deed through a quiet little title action. Scenario 4. Guardianship and conservatorship. If no POA exists and the person is already incapacitated, a court may appoint a guardian, broad authority, or conservator, financial authority. These representatives must get court approval before transferring a deed. They operate under ongoing court oversight and must file periodic accountings. Mental wellness and ownership on home ownership. The article includes research showing that home ownership supports mental wellness, offering a sense of control, reduced stress, better cognitive outcomes. This reinforces the idea that capacity could be supported and preserved whenever possible, not assumed, lost. Single most important takeaway: a deed transfer is only valid if the person signing has the mental capacity to understand it, or if a legal authorized representative signs on their behalf. Everything hinges on capacity, timing, and proper legal authority. Okay, here's part 3, guys. Okay, here's part 3 of B. Legally transferring property ownership when a family member is affected by dementia. The core idea of the page. The page lays out a step-by-step legal roadmap for families who need to manage or transfer property when a loved one has dementia. Its central message: you must put the right legal tools in place early. because dementia affects capacity, and capacity affects whether a person can legally transfer property. The article is practical, not theoretical. It's written to help families avoid disputes, protect assets, and maintain dignity. Durable power of attorney, DPOA. The foundation. The page emphasizes that the DPOA is the first and most important tool. A DPOA lets a trusted person manage finances for the individual with dementia. It remains valid even after incapacity. Must explicitly authorize real estate actions, e.g., selling, refinancing, transferring property. The article stresses that the document should be broad enough to be useful, but not so broad that it creates unnecessary risk. 2. Setting up a trust, more control, and smoother transitions. A revocable living trust is presented as a more comprehensive option. According to the page, a trust allows the person with dementia to stay in control while they still have capacity. Seamlessly shifts management to a successor trustee when capacity is lost. Avoids probates. Provides a clear structure for managing property long term. This is framed as a way to reduce conflict and keep decisions private. 3. Disability panel, a modern family-centered tool. The article introduces a disability panel, which is a group of trusted individuals who determine when the trustee no longer has capacity. This avoids court involvement, public declarations of incapacity, family conflict over who decides. It's described as a respectful, dignity preserving approach. 4. Advanced healthcare directives. While not directly about property, the AHCD is introduced because medical incapacity and financial incapacity often intersect. The A the A the H the AHCD names someone to make medical decisions, includes end of life preferences, ensures the person's wishes are honored when they can't speak for themselves. Protecting the home from Medicaid real estate recovery. The article explains that Medicaid may not or may try to recover cost from the home after the person dies, but there are exemptions. Child caregiver exemption. An adult child who lived in the home for 2 years and provided care may be able to receive the home sibling exemption. A sibling with an equity interest who lived with the home for a year may be protected. These exemptions are presented as lifelines for families trying to keep the home. 6. Challenging rights. Challenging right of survivorship. The property is held in joint tenancy with right of owner of survivorship. The article notes that this can sometimes be challenged. Reasons include the deeds does not clearly state survivorship, undue influence, especially common with vulnerable elders. A co-owner was pressured or misled. If successful, the property may instead be treated as tenants in common, which changes inheritance outcomes. Single most important takeaway: transferring property when dementia is involved requires early planning, the right legal documents, and an understanding of Medicaid's rules. Okay, guys, that is your B for now. I will be back on with C shortly. Give me a bit for that, please, and I'll be right back on for that. For now, Gator Wellness, take care, folks.